April 1996. Lyle and Erik Menendez were sentenced to life without parole. Their lawyers immediately said, "We'll appeal. This isn't over." For 28 years, they filed appeal after appeal, habeas corpus petitions, motions for new trials, claims of judicial error, constitutional violations, new evidence, every legal avenue available, and every single one failed, until 2023. What changed? Why did 28 years of legal battles produce nothing, and then suddenly, everything shifted? The answer reveals how the American justice system works, who it protects, and why second chances are so impossibly rare. What is an automatic appeal? In California, every death penalty or life without parole sentence automatically goes to appellate review. The defendant doesn't have to request it. It happens automatically. The Menendez automatic appeal focused on judicial errors during trials, prosecutorial misconduct, evidence admission exclusion issues. The defense arguments. Argument 1. The judge limited abuse testimony. In the second trial, 1995-96, Judge Stanley Weisberg restricted how much abuse evidence the defense could present. The first trial allowed extensive testimony. The second didn't. Defense. This denied our clients a fair trial. The jury didn't hear the full context. Argument 2. Separate juries should have been used. The first trial had 2 juries, one for Lyle, one for Erik. The second trial had 1 jury for both. Defense. The brothers have different defenses. They needed separate juries. Argument 3. Media coverage tainted the jury pool. The trial happened during the O.J. Simpson media frenzy. Court TV covered everything. Defense. It was impossible to find impartial jurors. The verdict was predetermined by public opinion. Argument 4. The prosecution withheld evidence. Defense claimed prosecutors didn't turn over all evidence as required. Defense. Brady violation. We didn't get full discovery. That's constitutional error. The appellate court's response. 1998. Denied. The California Court of Appeal ruled the trial judge acted within his discretion. The limitations on abuse testimony were reasonable. The jury heard sufficient evidence to make an informed decision. The verdict stands. Why did it fail? Appellate courts give enormous deference to trial judges. Unless there's clear, obvious error, something that would have changed the outcome, appeals are almost always denied. The standard is, would a reasonable jury have reached a different verdict if this error hadn't occurred? In the Menendez case, the appellate court said, no, the jury heard enough. The errors weren't significant enough. Result. Lyle and Erik remain in prison. After the Court of Appeal denied their petition, the defense went higher. California Supreme Court review. This is the highest court in California. If they take your case and rule in your favor, you might get a new trial. But they rarely take cases, and they almost never overturn murder convictions. The defense petition. The trial court's restrictions on abuse testimony violated our client's constitutional right to present a defense. This isn't about disagreeing with the verdict. This is about fundamental fairness. The prosecution's response. The defendants received 2 full trials. Both juries convicted them. The abuse testimony was heard, just not to the excessive extent the defense wanted. Justice was served. The California Supreme Court decision, 2000. Denied review. The court declined to even hear the case. This is common. The California Supreme Court accepts less than 5% of petitions. When they deny review, it means the lower court got it right. We see no reason to intervene. Result. Lyle and Erik remain in prison, but the brothers didn't give up. Over the next decade, they tried a completely different legal strategy, one that almost nobody succeeds with. What is habeas corpus? Latin for, you have the body. It's a petition that says, my imprisonment is unconstitutional. Release me or give me a new trial. It's the final legal option after all state appeals fail. The federal system. After California courts denied all appeals, the defense went to federal court, U.S. District Court, Federal Appeals, U.S. Supreme Court. This process takes years, sometimes decades. The Menendez federal habeas petition, filed 2001. Claim 1, ineffective assistance of counsel. Our trial lawyers didn't adequately represent us. They made critical errors that prejudiced our defense. This is a common habeas claim, but it's incredibly hard to prove. The standard, you have to show that your lawyer was so incompetent that it affected the outcome. Specific allegations. Leslie Abramson didn't call certain expert witnesses. Defense didn't challenge certain prosecution evidence effectively. Trial strategy was flawed. The problem, Leslie Abramson was one of the best criminal defense attorneys in America. Proving she was ineffective was nearly impossible. Claim 2, prosecutorial misconduct. The prosecution made improper arguments to the jury. They inflamed passion and prejudice. Specific examples. Pamela Bozanich's closing argument allegedly attacked the brothers' character beyond what evidence showed. Prosecution allegedly withheld exculpatory evidence. Claim 3. Judicial bias. Judge Weisberg showed bias against the defense throughout the trial. Evidence cited: rulings favored prosecution, abuse testimony restriction, demeanor toward defense attorneys. Claim 4. Jury misconduct. Jurors discussed the case before deliberations. Some jurors had made up their minds before hearing all evidence. The federal court's response, 2005. Denied. U.S. District Judge ruled: while the defendants raised serious concerns, none rise to the level of constitutional violation. The state courts thoroughly reviewed these issues. This court will not second-guess their determinations. Why did it fail? Federal habeas review is extremely narrow. Federal courts will only overturn a state conviction if the state court decision was unreasonable, there was a clear constitutional violation, the error affected the outcome. The federal judge found none of those things. Result: Lyle and Erik remain in prison. The defense appealed the district court's denial to the Ninth Circuit Court of Appeals. The Ninth Circuit is considered more liberal than other circuits. If any federal court would be sympathetic, it would be this one. The appeal arguments. The district court erred in denying habeas relief. The state trial was fundamentally unfair. The constitutional violations are clear. The Ninth Circuit decision, 2007, affirmed denial. The three-judge panel ruled unanimously: we find no error in the district court's decision. The petitioners received adequate representation and a fair trial under the circumstances. One judge wrote a concurrence: I am troubled by some aspects of this case. The restrictions on abuse testimony were severe. However, I cannot say they rose to constitutional error. This is a policy question for legislatures, not court. This was the closest the brothers came to any judicial sympathy. But sympathy doesn't overturn convictions. Result: Lyle and Erik remain in prison. The final step in the federal system, the U.S. Supreme Court. Petition for writ of certiorari. This asks the Supreme Court to review the Ninth Circuit's decision. The Supreme Court receives about 7,000 to 8,000 petitions per year. They grant about 80 to 100. That's about 1%. The Menendez petition. This case presents important questions about the constitutional right to present a defense in abuse cases. The court should grant review. The reality: the Supreme Court almost never takes criminal cases unless there's a circuit split. Different circuits ruling differently. It involves a major constitutional question. The case has national significance. The Menendez case had none of these. The Supreme Court's response, 2008, certiorari denied. No written opinion, just a one-line order, petition denied. This meant, we're not interested in this case. Result: Lyle and Erik remain in prison. For 12 years, the brothers tried every legal avenue. All failed. But in 2017, they discovered a new legal theory that would eventually change everything. Between 2008 and 2023, Lyle and Erik filed multiple motions claiming new evidence. California law allows new trials if new evidence is discovered after conviction. The evidence is material and credible. It couldn't have been discovered earlier with reasonable diligence. It would probably change the outcome. The attempts. 2010. New psychological evidence. Defense filed motion claiming new research on trauma and abuse better explained the brothers' behavior. Court response: this isn't new evidence, it's new interpretation of old evidence. Denied. 2013 witness recantation attempt. A prosecution witness allegedly wanted to change their testimony. Court response: investigation showed the witness wasn't actually recanting. Denied. 2017, Roy Rosselló surfaced. Roy Rosselló, former Menudo member, told friends that Jose Menendez had raped him as a child, but this wasn't formalized yet. No sworn statement. No documentary evidence. The defense couldn't file a motion yet. 2018, prison reform arguments. Defense argued that California's sentencing laws had changed. Juveniles sentenced to life could now seek resentencing. The problem: Lyle and Erik weren't juveniles when sentenced. They were 21 and 18. Adult. Court response: this law doesn't apply to your clients. Denied. 2019-2022, COVID-related petition. During COVID, many inmates filed petitions for compassionate release. The defense tried. Our clients are aging. They pose no threat. COVID makes prison dangerous. Court response: life without parole means life. Compassionate release doesn't apply to your clients. Denied. Why did all these fail? Because none met the legal standard for new evidence. Courts don't want to retry cases 20+ years later based on new interpretations or sympathetic arguments. They want hard evidence that definitively proves innocence or serious legal error. Result: Lyle and Erik remain in prison. May 2023. The documentary Menendez plus Menudo, Boys Betrayed, was released. In it, Roy Rosselló made a sworn statement. Jose Menendez drugged and raped me when I was 13 years old in the 1980s. This was different from previous attempts because it was sworn testimony, under oath. It was independent corroboration. Rosselló had no reason to lie for the brothers. It matched their abuse claims, same perpetrator, same methods. It was credible. Rosselló was a celebrity with his own reputation to protect. The second piece of evidence. Andy Cano's mother found the original envelope from Erik's 1988 letter. It had a postmark, December 1988. This proved the letter was written before the murders, not fabricated after. Why these two pieces mattered. Together, they did what 27 years of appeals couldn't. They provided external corroboration of the abuse claims. October 2023, new habeas corpus petition filed. The defense filed a new habeas petition based on this evidence. The argument, the jury in 1996 didn't have this evidence. If they had known, Jose's abuse was corroborated by an independent victim. Erik's 1988 letter was definitively pre-murder. They might have reached a different verdict. At minimum, manslaughter instead of murder. October 2024, DA Gascon's recommendation. Los Angeles District Attorney George Gascon reviewed the petition. He announced, "I support resentencing. This new evidence is significant." This was unprecedented. Prosecutors almost never support defense petitions. But Gascon saw what 28 years of appeals couldn't show. Real, new, credible evidence. The systemic reasons. 1 point, appellate courts defer to trial courts. Unless there's obvious error, appellate judges trust the trial judge's decisions. 2. New evidence. Standard is impossibly high. You have to prove it's truly new, not available before. It's credible, it would change the outcome. Most new evidence claims fail because they're really just new arguments about old evidence. 3. Finality matters to the system. Courts value finality. Once a case is decided, they don't want to relitigate it endlessly. 4. Procedural barriers are real. If you miss a deadline, raise an issue too late, or file in the wrong court, you lose, even if you're right on the merits. 5. The burden is on the defendant. You have to prove the system made a mistake. The system doesn't have to prove it got it right. The Menendez specific reasons. 1. They were convicted by 2 separate juries. This made it harder to claim error. If one jury got it wrong, maybe, but 2. The crime was heinous. Shotgun murders of sleeping parents. Courts are less sympathetic to heinous crimes. 3. Public opinion was against them. In the 1990s, the narrative was, rich kids killed for money, hard to overcome. 4. The abuse evidence was contested. It wasn't like they had medical records or photos. It was testimony. Contested testimony. 5. Leslie Abramson was brilliant. You can't claim ineffective assistance when you had one of the best lawyers in America. But here's the most important lesson from 28 years of failed appeals. The system isn't designed to correct injustices. It's designed to finalize them. The harsh truth. The American legal system is not designed to find truth. It's designed to resolve disputes efficiently and with finality. What this means, once you're convicted, the presumption flips. Before trial, you're presumed innocent. After conviction, you're presumed guilty, and overcoming that presumption is nearly impossible. The statistics. Less than 1% of appeals result in reverse convictions. Less than 0.1% of habeas petitions succeed. The average time from conviction to execution in death penalty cases is 20+ years. Why? Because the system has multiple layers of review, and each layer defers to the one before. Trial court, appellate court, state Supreme Court, federal district, federal appeals, U.S. Supreme Court. Each level says, the court below already reviewed this. We trust their judgment. The result, even if you're right, you lose. Even if there's new evidence, you lose. Even if the original trial was flawed, you lose. Unless your case meets an impossibly high standard. Some convictions do get overturned. When? 1 point. DNA evidence proves innocence. The Innocence Project has freed 375+ people using DNA. But the Menendez case has no DNA issue. They admitted killing their parents. 2. Prosecutorial misconduct is egregious. If prosecutors hid evidence, lied to the jury, or violated rights blatantly. But in the Menendez case, the prosecution played by the rules. 3. Key witness recants. If the main witness admits they lied, but in the Menendez case, there's no witness recantation. 4. The law changes. Sometimes new laws apply retroactively. California did this with juvenile sentencing. But Lyle and Erik were adults. 5. Cultural shift, political will. This is what's happening now with the Menendez case. The culture has shifted on male abuse victims, and a progressive DAG Gascon was willing to act. As of January 2026, the 2023 habeas petition is pending. Judge Michael Jespers postponed ruling multiple times. The hearing scheduled for January 30, 2025 was continued. Nathan Hochman, new DA, opposes the petition. The legal arguments. Defense. New evidence changes everything. Resentence to manslaughter. Release them. Prosecution. The new evidence is interesting, but not dispositive. The jury's heard abuse claims and still convicted. The verdict should stand. The likely outcomes? 1. Petition granted. Resentencing hearing. Possible release. 2. Petition granted. Resentencing to manslaughter. Parole hearing required. 3. Petition denied. They remain in prison indefinitely. 4. Compromise. SRO. Some form of relief. Short of relief. 28 years. Dozens of appeals. Every legal avenue exhausted. And every single one failed. Until 2023, when real new evidence emerged. What does this teach us? 1. The system resists change. Convictions are hard to overturn by design. 2. Evidence matters more than argument. New legal theories don't work. New evidence might. 3. Timing is everything. Cultural shifts matter. The same evidence in 1996 might not have mattered. In 2023, it did. Politics matter. A progressive DA made the difference. A conservative DA is now opposing. 5. Justice is slow. 28 years of waiting. And still no resolution. Conclusion. The appeals that taught us about the system. Lyle and Erik Menendez filed appeal after appeal for 28 years. They lost every single one. Not because they were wrong, but because the system isn't designed to let you win. The appeals revealed how high the bar is for overturning convictions, how much deference courts give to trial judges, how procedural rules can defeat substantive justice, how finality trumps truth, how rare second chances are. But they also revealed that persistence matters, that new evidence can change things, that cultural shifts affect justice, that political will matters, that hope isn't always foolish. 28 years of appeals failed, but one documentary and one letter might succeed. Not because the legal arguments got better, but because the world changed. And maybe that's the real lesson. Justice isn't just about law. It's about culture, politics, timing, and who's listening. The appeals didn't free Lyle and Erik, but they kept the door open long enough for the world to catch up. For 28 years, Lyle and Erik Menendez fought the American legal system. They filed every appeal. They raised every argument. They presented every piece of evidence they had, and they lost every single time. Not because they were wrong, but because the system is built to resist change. Appeals courts don't want to second-guess juries. Judges don't want to admit mistakes. The system wants finality, not justice. But then something unexpected happened. The world changed. A documentary aired. A letter was verified. And suddenly, the same arguments that failed for 28 years started to work. The lesson? Sometimes justice isn't about better legal arguments. It's about waiting for the world to be ready to hear them.